5, 4, 3, 2, 1, start.
The suit was decided on the basis of the findings on issue number 1 full stop. The remaining issues number 2 to 5 were not pressed by the defendants and were accordingly decided against them full stop. On issue number 1, both the courts below have held that from the testimony of workers Sandeep, Rajendra alias Raju and contractor Dheeraj, it was established that the deceased was in employment of the contractor and on the fateful day he was on duty along with the aforesaid workers full stop. On that day, the two had seen the contractor making a phone call to the department to take permission for carrying out work on the electric line full stop. The department had given him permission, assuring that electricity had been stopped to facilitate work by the contractor's worker full stop. It has also come in evidence of the department witness Birender Singh SDO that the contractor had a license full stop. Stanza on 10 December 2015, permit number 57 was issued for discontinuing power supply on the feeder in village Mandoti full stop. The postmortem report also established that the deceased died due to electrocution and its complications, which were antemortem in nature and sufficient to cause death in the ordinary course of nature full stop. Undisputedly, a policy of insurance had been issued by the insurance company in favor of the contractor, covering the risk by payment of compensation on account of injury and death of any of his worker during the course of employment full stop. The contractor was not found to be covered under any of the exclusion clauses of the policy full stop. On account of these findings of negligence, recorded insurance company was held liable to pay the compensation which was assessed by applying the principles laid down for assessing compensation on account of death in the Motor Vehicles Act 1988 full stop. Keeping in view the age, income and number of dependents of the deceased and by applying adequate multiplier of 14, an amount of rupees 15 lakh was awarded as compensation to be paid by the insurance company along with interest at the rate of 5% per annum from the date of filing the suit till its realization full stop. Stanza. The plaintiffs were accordingly directed to affix ad valorem court fees on the awarded amount of compensation within 2 months of the passing of the judgment full stop. Learned counsel for the insurance company has raised two false submissions to challenge the impugned judgment and decree full stop. Firstly, he has contended that civil court jurisdiction to try the suit is barred full stop. Reliance has been placed on Section 19 of the Employees Compensation Act 1923 bracket start foreshowed the act bracket close in that regard full stop. According to him, the compensation payable as well as the liability to pay the same on account of death of Sri Ram Prasad, who was the contractor's employee, can only be adjudicated by a commissioner under the act full stop. Secondly, learned counsel has contended that the courts have wrongly adopted the method of calculating the amount of compensation full stop. In case the compensation becomes payable, it has to be assessed under the Act of 1923 and not under the Motor Vehicles Act 1988 full stop. Stanza. Per contra, learned counsel for the respondent has asserted that judgments of both the courts below are based on admissible evidence and provisions of the Motor Vehicles Act have been rightly applied for assessment of compensation as per law settled by this court full stop. There is nothing wrong about it full stop. learned counsel for the parties have been heard, full stop. The following substantial question of law arises for consideration in the instant regular second appeal, full stop. Whether provisions of Section 3 and 19 the Employees Compensation Act 1923 bar jurisdiction of civil courts to entertain a suit for damages oblique compensation on account of death or injury suffered by an employee during the course of employment, full stop. To decide the issue raised in the appeal with regard to jurisdiction of a civil court to decide the suit for compensation oblique damages, a reference needs to be made to Section 3 and 19 of the Act of 1923, which are reproduced here, that nothing herein contained shall be deemed to confer any right to compensation on a employee in respect of any injury if he has instituted in a civil court a suit for damages in respect of the injury against the employer or any other person, and no suit for damages shall be maintainable by a employee in any court of law in respect of any injury, full stop, stanza. If he has instituted a claim to compensation in respect of the injury before a commissioner, or if an agreement has been come to between the employee and his employer providing for the payment of compensation in respect of the injury in accordance with the provisions of this act, full stop. If any question arises in any proceedings under this act as to the liability of any person to pay compensation, including any question as to whether a person injured is or is not a employee, or as to the amount or duration of compensation, the question shall, in default of agreement, be settled by a commissioner, full stop. No civil court shall have jurisdiction to settle, decide, or deal with any question which is by or under this act required to be settled, decided, or dealt with by a commissioner, or to enforce any liability incurred under this act, full stop. The provisions of subsection 5 of section 3 lay down that the act of 1923 shall not confer any right of compensation on an employee in respect of any injury suffered if he has instituted a suit for damages in a civil court in respect of the injury against the employer or any other person, full stop, stanza. Further, under clause A of subsection 5 of section 3, the employee shall have no right to file a suit for damages in a civil court in respect of the injury if he has instituted a claim for compensation with respect to the injury before a commissioner under the Act of 1923, full stop. Under clause B of subsection 5 of section 3, also the employee shall have no right to file a suit for damages if an agreement has been reached between him and the employer providing for payment of compensation with respect to the injuries suffered as per provisions of the Act, full stop. Accordingly, there are two conditions which bar filing of civil suit for damages by an employee when he has instituted a claim for compensation with respect to injuries before a commissioner, when under the Act, when an agreement has been arrived at between the employee and his employer providing for payment of compensation as per provisions of the Act, full stop, stanza. The second condition is not attracted to the facts of the instant case, as no agreement is said to have been arrived at between the plaintiffs and the employer oblique contractor for payment of compensation, full stop. Under provisions of subsection 5 of section 3, both the civil court as well as commissioner under the Act of 1923 have the jurisdiction to decide the issue of payment of damages oblique compensation to an employee on account of an injury suffered in the course of employment full stop. The jurisdiction of civil court to decide the issue is not barred full stop. In fact, the bar is on invoking both the jurisdictions simultaneously to decide the issue of payment of damages oblique compensation on account of the injury suffered full stop.